Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Jitendra Navnitlal Upadhyay vs. Income Tax Officer, pronounced by Rajkot Tribunal on the 22nd of May 2026. The assessee, an individual, filed his return of income for assessment year 2013-14. The assessing officer, AO, noted from the ITD portal that the assessee sold non-agricultural land on the 9th of May 2012 for Rs 5 lakh, purchased on the 25th of May 2011 for Rs 4 lakh 90,000. Since the holding period was less than 1 year, the AO concluded it attracted short-term capital gain, STCG, of Rs 30 lakh 5,000 after deducting cost of acquisition. The assessee had not offered any capital gain in his return. The AO reopened the assessment under Section 147 after recording reasons and obtaining prior approval from the Principal Commissioner of Income Tax, Jamnagar, on the 31st of March 2021. Notice under Section 148 was issued, and the assessee filed a copy of his return. During reassessment, the AO issued notices under Section 142(1), but never issued a notice under Section 143(2). The assessee sought adjournments but failed to submit documentary evidence. The AO made an ex-parte addition of Rs 30 lakh 5,000 as STCG under Section 144 read with Section 147 and 144B. The Commissioner of Income Tax, Appeals, confirmed the addition and even enhanced the STCG to Rs 56 lakh 43,358. Aggrieved, the assessee appealed to the ITAT. The assessee's counsel, Shri Dushyant Maharshi, argued that the AO had issued only notices under Sections 148 and 142(1), but not under Section 143(2). He contended that without such notice, the reassessment order was void ab initio, relying on the Supreme Court's judgment in Hotel Blue Moon 2010-188 Taxman 113, Supreme Court. The tribunal meticulously examined the records and verified that only notices under Sections 148 and 142(1) were issued. No notice under Section 143(2) was ever served on the assessee. This factual finding was undisputed. The tribunal referred to the Supreme Court's decision in Hotel Blue Moon, which dealt with block assessments but laid down a principle of universal application. The Supreme Court held that where an assessment is to be completed under Section 143(3), read with Section 158 BC, notice under Section 143(2) must be issued within 1 year from the date of filing of the return. Omission to issue such notice is not a procedural irregularity but a jurisdictional defect that cannot be cured. The tribunal applied this ratio to reassessment proceedings under Section 147, noting that the scheme of reassessment under Section 147 read with Section 144B also requires the AO to follow the procedure under Section 143(2) and 3. The AO had issued notices under Section 142(1), but not under Section 143(2), which is a sine qua non for assuming jurisdiction to frame an assessment under Section 143(3). Without such notice, the reassessment order is null and void. The tribunal held that the reassessment order under Section 147 read with Section 144 and 144B was bad in law and liable to be quashed. Consequently, the penalty under Section 271(1)(c), which was dependent on the reassessment, also fell through. The tribunal allowed both appeals, setting aside the CIT.A.'s order and the AO's assessment. The ITAT Rajkot's order in Jitendra Navnitlal Upadhyay is a classic reminder of the primacy of procedural compliance in tax law. By quashing the reassessment for want of a mandatory notice under Section 143(2), the tribunal reinforced the principle that jurisdictional defects cannot be cured by subsequent compliance or by the merits of the addition. The decision aligns with the Supreme Court's stance in Hotel Blue Moon and other precedents, ensuring that taxpayers are not subjected to assessments without due process. Question: What was the main reason for the ITAT quashing the reassessment order? Answer: The ITAT quashed the reassessment order because the assessing officer failed to issue a mandatory notice under Section 143(2) of the Income Tax Act during the reassessment proceedings. The tribunal held that this omission rendered the reassessment void ab initio, following the Supreme Court's decision in Hotel Blue Moon. Question: Did the ITAT consider the merits of the addition made by the assessing officer? Answer: No, the ITAT did not examine the merits of the addition, short-term capital gain of Rs 30,05,000, because the procedural defect of non-issuance of Section 143(2) notice was sufficient to quash the entire reassessment. The tribunal focused solely on the jurisdictional issue. Question: What is the significance of the Hotel Blue Moon judgment in this case? Answer: The Hotel Blue Moon judgment established that notice under Section 143(2) is mandatory for completing an assessment under Section 143(3), and its omission is a jurisdictional defect, not a curable procedural irregularity. The ITAT applied this principle to reassessment proceedings under Section 147. Question: Was the penalty under Section 271(1)(c) also deleted? Answer: Yes, the penalty under Section 271(1)(c) was deleted because it was dependent on the reassessment order. Since the reassessment itself was quashed, the penalty had no legal foundation and was consequently set aside. Question: What lessons can tax practitioners learn from this order? Answer: Tax practitioners should always verify whether the assessing officer issued a notice under Section 143(2) during reassessment proceedings. If such notice is missing, the reassessment order can be challenged as void ab initio, regardless of the merits of the addition. This case highlights the importance of procedural compliance in tax litigation. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@TaxPundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.